Hello and welcome to the webinar, Mitigating and Discussing the Potential Cyber Risks, a Boardroom Priority. There is no part of the world that has not felt the effects of COVID-19. And with this, business disruptions caused by the pandemic has created a number of new cybersecurity risks. Combining this with the trend around the world towards remote working, cyber risks and companies that are set to face them are only likely to increase. For general counsel who often find themselves at the forefront of managing such attacks, knowing how to respond to these threats goes beyond the knowledge of black letter law. Our session today is designed to provide GCs and business owners with the essential knowledge on the practical steps that can be taken to mitigate, manage and overcome cyber incidences, whilst also delivering relevant and practical insights into the evolving regulatory landscape. My name is Haveen and I'm one of the digital editors here at the Legal 500. Today, I would like to warmly welcome our expert panel, who, as industry leaders in Australia and beyond, will be sharing their thoughts and experiences. In no particular order, I'd like to welcome Helen Clark, partner at Cause Chambers in Westcraft. Helen is a technology, intellectual property and data privacy specialist with extensive experience acting for high-profile government and corporate clients in a diverse range of industries, including health, energy, telecommunications, financial services, and manufacturing. That's just to name a few. She is one of the lead partners within the Cause cyber team. In addition to this, Helen is a frequent advisor on telecommunications projects and regulations in Australia, providing key advice on network rollouts, wholesale and retail service arrangements, carrier licensing, and service provider regulation. Welcome, Helen. It's great to have you here with us today.
Thanks very much, Haveen. Great to be here.
Our next panelist is one of the founding partners of the Cause cyber team. That's Michael Du Rosario. He specializes in cases that have long-term strategic implications for clients. He's also recognized as an excellent technical and outcomes-focused litigator capable of dealing with complexity and large amounts of information. Some of his experience areas include product liability law, inquiries and investigations, commercial litigation, constitutional law, and privacy. The list does go on. Michael is also acknowledged as being one of the leading alternate dispute resolution practitioners in Australia. As the head of the Cause Legal Technology Solutions Group, Michael leads a team of more than 15 legal and technology specialists. Thank you for joining us today, Michael.
Great. Thank you, Harvey.
Last but not least, we would like to warmly welcome Phil Cantina, partner at Cause. Phil is a dual qualified in law, computer science, and understands the unique and often technically complex issues that businesses face on data privacy and technology. He has acted for some of Australia's leading organisations in their tech procurement and implementation transaction and is regularly advised on resolving technology disputes. Phil is widely respected in data privacy and technology legal community here in Australia and globally. Very notably, if I may say so, he has also been acknowledged and featured in our Hall of Fame for IT and telecoms matters here at the Legal 500. It's great to have you here with us today, Phil.
Thank you, Haveen, and hello, everyone.
So now with the formal introductions out of the way, we would just like to give a special thanks for the sponsors of the event today, which is Cause Chambers in Westcraft. Before I hand over the reins to Helen, I just wanted to let the audience know that if you do have any questions throughout the session, you can write them in our Q&A chat boxes on the screen and our lovely panelists will be able to view them. With that being said, I will now hand over the session. Thank you, Helen.
Thank you, Haveen. Let's begin. Before we do kick off, I would, although of course we are gathering together for this discussion on a virtual basis, I would like to pay our respects to the traditional owners of all the lands on which we are meeting today and acknowledge them and pay my respects to their elders past, present and emerging. Let's get underway, and next slide, Giuliano, which will really set the scene with a very sobering headline from the Australian Financial Review earlier this year. This regulatory train of cyber risk management barreling towards directors. It's a pretty sobering thought. In terms of what we will cover today, to set the scene, I will kick off with a bit of a discussion about some issues with ransomware For those of you who keep up with cyber and technology press, you will have been reading about a number of these high-profile attacks recently. And yes, they are increasing in their frequency and impact. Then we'll have a look at an organisation's key legal obligations in relation to cyber attacks and also obligations to be cyber resilient, in fact. And this includes obligations not just imposed on an organisation, a company itself, but also directly on individual directors of companies. Then Phil will walk us through where the law is heading, because appropriately, the law is really evolving in this space, and we are looking at some upcoming changes, particularly in Australian regulation of cybersecurity. Michael will walk us through some key insurance considerations and some changes in that space, particularly in relation to cyber insurance. And we'll also have a look at insurance implications and the payment of ransoms in particular. And then Phil will round out the discussion with some top 10 cyber commandments for in-house counsel. So that gives you a bit of a flavour of what we will cover today. Next slide, please, Juliano. So hopefully this is a nice, clear picture for all of you. We've all heard the saying that data is the new oil. It well and truly is. As the value of data is becoming increasingly well recognised by all companies and governments and businesses, it's really important to understand how to protect that value, the value that data has. And if we look at it in terms of the triangle that you can see, protecting the value of data requires three key things. The first is confidentiality. So that is controlling who knows the information. The second is availability. So the information is there when you need it. You can access it, you can use it to run your business and operations. And the third piece is integrity, which means the information is not corrupted. So they are the three key areas that are really at the heart of cybersecurity. When we talk about cybersecurity, we are talking about threats to any or all of these three features. And any of those threats would quickly erode an organisation's ability to harness the value of its data, or at least involve a very costly remediation exercise to get that data back to where it needs to be, where it is confidential, available, and has integrity. Next slide, please. So what is ransomware? If you have ever turned your computer on in the morning or in the evening and seen a message like this, that is not a good thing to see. What we'll talk through now are just some of the key features and causes of ransomware attacks and what they evolve, and these are evolving as well. So in our experience in this area, the underlying root cause of a ransomware attack involves exploitation of a device or a server that's running the remote desktop protocol, exploitation of an unpatched vulnerability in an application. And this is particularly prevalent on things like legacy services that have been in use for a long time or are in the process of being migrated to a new environment. And thirdly, malicious software that is primarily sent as an email attachment or is accessed through a link provided within an email. And what we're seeing in particular more recently is malicious macros in Microsoft Office documents that are attached to emails are of high risk. They're a high source of risk presently. In our experience also, ransomware attacks principally occur in one of two ways. So the first is that the malicious actor encrypts all or critical files and folders on a device or on servers on a network server, and then demands payment to provide a decryption key. So similar to the scenario you see on the screen there. And the second scenario, which we are increasingly seeing, is that the malicious actor gains access to a network. The actor then undertakes a reconnaissance mission, if you like, to determine the most critical or sensitive files, things like billing, finance, governance, personnel, and then exfiltrates some or all of that data, so takes it out of the system. The exfiltration can occur over a period of time, 1 or 2 weeks, even longer in some cases, to minimise detection that might otherwise occur. if large quantities of data leave a particular system or leave the organisation. And then once the malicious actor has the data that it requires, the servers are then encrypted. The malicious actor then demands a payment to provide the decryption key. And then subsequently, or at the same time, the malicious actor then contacts the victim organisation and threatens to release some or all of the data that has been exfiltrated unless a second ransom payment is made. And that is usually now additional to the payment that is made to actually provide the decryption key in the first place. And then if the ransom is paid, the malicious actor will undertake to delete the exfiltrated data and provide proof of that and assurance that that has occurred. And in some cases, malicious actors will release a small quantity of data, typically less sensitive in nature, on some kind of public internet forum as proof of their willingness to publicly release information that they have exfiltrated if the victim organisation doesn't pay the ransom. And it's recently been reported as well, and we have seen this in some circumstances, that malicious actors are also contacting third-party clients or customers of the victim organisation. They have their contact details through the data that they have exfiltrated, and are encouraging those persons to pressure the victim organisation into paying the ransom to delete the ransom to prevent the actual end customer's information being released online. And we've got some examples of that coming up. So they're becoming two-pronged attacks, not just on the victim organisation, but also on the victim organisation's customers, if you like, are becoming involved as well. In our experience too, malicious actors will also offer to provide detailed information and in some cases tech support to the victim organisation to explain how they breached the security in the first place, and also how to help them get their systems back online and access to their data again. So despite their apparent willingness in some circumstances to be helpful though, there is also in our experience a residual risk that malicious actors may have installed a rootkit or created a user account within the victim's network to maintain persistence. So there is an ongoing risk that they may continue to have access to networks despite payment of a ransom. So that's just a little bit of a quick run through some of the technicalities of ransomware attacks. If we go to the next slide, we just have some headlines to demonstrate the sorts of things we're dealing with and the types of names involved. You would think that as businesses become more cyber sophisticated and resilient, that the number of attacks and the public scrutiny of those attacks would decrease, but that is just not the case. Cyber events are making headlines daily. Cyber events are evolving as fast as or faster than organisations' cybersecurity capability, and the real world impacts of those attacks are becoming increasingly more disruptive. And we'll look at some additional examples in the next few slides. The broader issue about ransomware in particular, and you'll see the headline there in relation to the Florida clinic, which was a medical practice that hackers infiltrated, took data, and then contacted patients of that clinic to say, we have your data, you also need to pay us a ransom to ensure that your data is not published online. So it's not just the practical implications, the practical impacts of cyber attacks that organisations need to deal with, it's also handling public scrutiny and criticism and potentially very significant impact on business reputation as well in all of these things. If we go to the next slide, we have some fairly sobering statistics in relation to ransomware in particular, and some visuals of the sectors where ransomware attacks are more common than others. So Coveware, which is where this information helpfully comes from, is an organisation that aggregates global ransomware data. And its most recent statistics, which are up there on the screen for Q1 2021, found that globally, so these are global figures, as you can see, the average payment, average ransomware payment was Australian 295,000, which was an increase of 43% from the previous quarter. The median ransomware payment was Australian $105,000. That's an increase of 59% from the previous quarter. 77%, that's a very significant majority of ransomware attacks involved a threat to release exfiltrated data. And of course, that is a more recent development. Original ransomware attacks were really just locking down systems to prevent access for the organisation. So that is that shift we've been discussing. And the most common attack vector is one of the ones I mentioned, which was compromised through the remote desktop protocol, the RDP, followed then by phishing through emails. They're the most common causes of attack. In terms of sectors that are impacted, you can see there on the slide, professional services, health, public sector are significantly vulnerable or frequent targets. The Australian Cybersecurity Service in Australia reported that the top 5 sectors to report ransomware incidents during the 2019-2020 financial year were, in this order, health, government, education, transport, and retail, respectively. So that gives you a flavour of the types of areas that are really dealing with cyber attacks. Then on the next slide, we have some useful graphs from a recently launched website called Ransomware with an H. Ransomware reports on cyber ransom payments across the globe based on both user reports and Bitcoin records. What ransomware doesn't do is publicly identify the payee of ransoms. On that left, on the graph on the left-hand side, we see the top 4 ransomware attacks for the full period that the website has been in operation, which totals US dollars 97 million, so close to $100 million US. Although interestingly, as it is otherwise estimated that ransomware payments in 2020 totaled approximately US 350 million, this is clearly just a proportion of total actual payments. Then on the right-hand graph, we see the top 6 ransomware attacks that have occurred this year and the payments made in those. So this data doesn't actually include the US $70 million demand in the Cassia ransomware attack, which used Revel. Cassia, as many you know, is a software service provider to approximately 800 to 1,500 organisations. So 70 of which are estimated to be managed service providers to hundreds of organisations. So that was quite a significant impact. The interesting thing to note about these graphs is that the Conti and Revel are the 3rd and 4th most lucrative ransomware attacks of all time based on the data that ransomware has collected, even though they've only been operating this year. So I think these graphs clearly show how ransomware threats are evolving and are actually becoming increasingly lucrative. If we go to the next slide, some logos, some big names who have more recently in the last couple of years been the victims of ransomware attacks. So we might just run through some of them. JBS Foods, in particular, leading global meat processor with operations in the United States, Canada, Europe, Mexico, and New Zealand, the UK and Australia, significant operations. So in June 2021, a couple of months ago, JBS confirmed that it had paid the equivalent of 14.2 million Australian dollars in response to a ransomware attack against its US and Australian operations. The US Federal Bureau of Investigation confirmed reports that the attack came from Revel, believed to be based in Russia. JBS made the decision to pay the ransom to mitigate unforeseen issues regarding the attack, including to ensure that no data was exfiltrated. And as reported, preliminary results suggest that no company, customer or employee data was compromised by that attack. But it is a clear example of a fairly significant ransom payment being made. Nine Entertainment. Nine was subject to the largest ransomware attack on a media company in Australia's history in late March this year, March 2021. While there was no ransom note as such in that case, staff were instructed to check their laptops for a file called recoveryinstructions.html, linking the attack to a strain of ransomware called Medusa Locker, which might be familiar to some of you. The attack was contained by isolating the company's corporate network from the rest of Nine Entertainment's operations. And a spokesman did confirm in reporting that no data had been removed from computer systems, but that attempts to isolate the hacker and the attack had affected normal operations, and no information has been published regarding the payment, any ransom payment demanded or paid. Nothing was reported on that front. Colonial Pipeline Co. in the US, that was an example that occurred in May 2021, earlier this year. It took just over 2 hours for hackers to gain control of more than 100 gigabytes of information from Colonial Pipeline, causing essentially the firm to shut down its fuel distribution network. And of course, then that sparked widespread fears of a gasoline or petrol shortage in the US. And the decision to pay off the attackers to make a ransomware payment was also made quite quickly. It has been widely reported that Colonial Pipeline's CEO agreed to pay a $5.6 million Australian ransom to DarkSide, the group that was behind that attack, because, and as it was reported, he said it was the right thing to do for the country. So that was a significant attack on major infrastructure with potential significant flow-on effects. Closer to home in Australia, Uniting Care Queensland, which is a not-for-profit health and hospital and aged care provider, fell victim to a ransomware attack in April this year. That attack was claimed by Revil. It affected Uniting Care Queensland's hospitals and aged care homes, leaving many of their digital and technology systems inaccessible for an extended period. Staff were not permitted to access work emails, significantly impacting on productivity. The Uniting Care confirmed in the end that it did find no evidence that the health and safety of patients or residents or clients was compromised by the incident, but it did have clearly a very significant impact on its day-to-day operations. In this case, no information regarding any ransom payment demanded or paid has been disclosed. And then finally, a couple from last year in 2020, which have been well publicised as well. Of course, Toll Group became aware that its systems had been infected by a variant of Mail2 ransomware. As many as 1,000 services in Toll's data centre were affected. It was reported then that a ransom was demanded, but that Toll did not pay. There was no indication that personal data was lost as a result of the attack. And then later in May 2020, Toll confirmed that it had in fact been the victim of a second attack identified as Nephilim. The stolen data included files from a corporate finance directory, including financial reports, cash flow statements, invoices, board reports, and Toll at the time declared that it again refused to deal or engage with the attacker's demands from the outset. The attacker in that case subsequently published to the dark web some of the information that was stolen from Toll servers, which included names, residential addresses, ages, and payroll information from a number of past and present employees. So for Toll, it was a double experience: initial attack in January, follow-up attack in May, as an example there. And finally, BlueScope Steel, May 2020, BlueScope announced that its IT systems had been infected by ransomware affecting its Australian manufacturing and sales operations. Steelmaking at Port Kembla was disrupted, with one mill temporarily being shut down and many processes having to switch to manual operation. It is understood that one or more employees in that case opened a contaminated email attachment that led to the infection. BlueScope has not otherwise clarified the nature of the incident, but it's a good example of how these things can actually impact operations and ongoing business rather than just data itself. So some interesting examples there. If we go to the next slide. Thanks, Giuliano. All of these examples and these statistics beg the question, what do organisations need to do by law when a cyber incident occurs and affects them? So we'll have a look at some of these. If we go to the next slide. In short order, there is no Cyber Security Act as such in Australia that regulates all aspects of cybersecurity. So rather, there are a patchwork of different laws, if you like, that each focus on discrete aspects of cybersecurity. And of course, in terms of cybersecurity, and we've seen through the examples I've just discussed, cybersecurity is not just about privacy. That is just part of it. One of the most notable laws in this area, of course, is the Privacy Act in Australia and an organisation's obligations under that Act, and APP 11, Australian Privacy Principle 11 in particular, obligations on organisations to take reasonable steps to protect personal information from a data breach. And this obligation is intentionally worded broadly and is technology agnostic, so that what is reasonable will clearly evolve with cybersecurity measures and threats. These things will change over time. And in terms of Privacy Act obligations, APP 11 is also supported by a notifiable data breach scheme, which requires personal information data breaches that give rise to a likely risk of serious harm to affected individuals to be notified to both those individuals and the Australian privacy regulator. So that law, as many of you will know, came into effect in February 2019. And since then, we've actually seen much more reliable statistics on the prevalence and type of major personal information data breaches. But important to remember, and as we've highlighted on the slide, cybersecurity is not just about privacy. What the data about data breaches that are notified under the Privacy Act doesn't tell us is information about data breaches that affect other types of information, such as commercially sensitive information. So if we go to the next slide, yet more legal obligations in this area. There are a number of sector-specific obligations that apply in relation to cyber security and data breaches, and these include, and there are a number, there are notification obligations under various state and territory criminal laws relating to serious indictable offences, such as the Crimes Act in New South Wales in particular. There are notification obligations that apply to financial services organisations, banks, insurers, superannuation funds, to report material security vulnerabilities and information security incidents to APRA, the Australian Prudential Regulation Authority, which regulates them under Prudential Standard CPS 234 on information security. So that's very specific to a sector. And has a number of different obligations. Then the security of critical infrastructure regime, it currently only applies to operators of critical electricity, gas, water and ports assets. Under that relevant act, the relevant minister can direct an entity to do something or refrain from doing something for a particular period where the minister thinks that there is a risk of an act or omission that could be prejudicial to national security. This could extend, of course, to giving cyber security related directions that must be complied with. And Phil will discuss down the track the plans in Australia for expanding the scope of this regime and some changes coming with that. If we turn to directors' duties, in Australia, of course, company directors are required to exercise care and skill when they are in relation to cybersecurity more broadly, and in particular when deciding whether or not to pay a ransom is an example of that. And what that requires is directors need to be adequately informed about particular events, the risks to the company and the company's options. And that doesn't mean directors themselves must be experts on all of those things, but what they need to do is ask the right questions of experts. They should generally seek expert advice in relation to cybersecurity and in relation to ransomware attacks if they occur. Another sort of particular example relevant to ransomware payments is directors' decisions to pay a ransom might be deemed to be made with care and skill when those decisions meet particular criteria under Section 180 of the Corporations Act, or the Business Judgments Rule, which means the decision is made in good faith, the decision is adequately informed, and the director reasonably believes that the decision is in the company's best interests. A ransomware attack, any kind of cyber event, including the payment or non-payment of a ransom, might also need to be disclosed to the Australian Stock Exchange in accordance with continuous disclosure obligations, if an event like that may have a material impact on share price. So that's an additional obligation. ASIC, the Australian Securities Investments Commission, has also published a number of resources about how companies and boards of directors can improve their cyber resilience. ASIC has for some time now taken an awareness and education approach, but it is also moving towards an enforcement approach in terms of obligations of financial services license holders and their obligations to have appropriate systems and security systems in place to address these issues. So as you can see from those examples of legal obligations, there are a number that apply, and also some of them will apply in particular sectors while others will not. In addition to the law, there will be contractual obligations that companies have under contracts they enter into with various parties for various reasons. So these may impact obligations to keep the other party's information confidential and include specific security obligations. There may be obligations on the company to notify of a disclosure of a breach of those obligations. So we're seeing that increasingly as well. So if we go to the next slide, I will now hand over to Phil, who will talk a little bit more about where things are heading in terms of cybersecurity regulation. Over to you, Phil.
Thanks, Helen. Thank you very much. Thanks, Helen, and hello again, everyone, and welcome to you all. There are some really good questions in the Q&A box, which we'll address at the end, if that's okay, but there are some really interesting thoughts and that we would like to deal with later. Just on what Helen was talking about in terms of ransomware, this is very much a board issue. It is not illegal per se for an organisation to make a ransom payment. It is incumbent upon the board to consider, and it is a board issue, as to whether or not the ransom should be paid. And there are all sorts of circumstances that are relevant to that, including the nature of the data, the nature of the attack, as to whether it's a denial of service attack, it's stopping you accessing the system, or is it simply, quote unquote, simply the publication of data or the threatened publication of data, which may not demand a ransom payment. But it's very much a decision for the board to make in the circumstances after being properly advised. On that slide, you'll see the ransomware bill on the right-hand side there. I think it's relevant just quickly to start off in terms of where things are potentially going, to just mention this ransomware bill. It was a bill, for those who are not aware of it, that was introduced earlier this year by the federal opposition, by the Labor Party, into the House of Reps. Didn't get through the House of Reps. It wasn't put on the agenda by the government for debate, but it's been reintroduced in the last couple of weeks in the Senate. For another go at getting this bill passed as a private member's bill. And what the ransomware bill does is it requires the reporting both by government and potentially by private sector entities to report the fact that a ransom payment has been made. It doesn't require in its current stance to actually seek approval or to give prior notice of a ransom payment, but it does say that if a ransom payment has been made, then you need to report it for certain types of businesses and for government entities. And there's a civil penalty if you don't report it of something like, I think it's 1,000 Commonwealth penalty units, which is about 1.8 million. But it, as I said, hasn't gotten through. But you can see that the intent behind this sort of thing is to increase the level of information about what's going on in the marketplace, basically to assist the government and the Australian Cybersecurity Centre to gather the whole plethora of information to try to deal with cyber attacks going forward. So it needs to know about what's going on in the industry. That's the ransomware bill. And we're unsure if it's going to get through and when it's going to get through. But if it does get through, it's a reporting instrument as opposed to a prohibition instrument, as it were. Folks, I'm teaching a subject at the Law School at the University of Melbourne called Data Law, and it's a heavily oversubscribed subject. It's the first year it's being taught as a full-blown subject, and it's a lot of it is about the direction of data and how it can be protected. And one of the students asked me the other day, what is the most popular area in practice when it comes to data? What's happening? What's the most prevalent in terms of the issues that we're seeing in terms of data? Is it licensing? Is it IP? Is it ownership? What is it? In fact, at the moment, and I suspect for the foreseeable future, it's the regulation of the security of data, how to protect it, what sort of regulations need to be put in place to enhance security. And this is something that we're all involved with, and general counsel of organisations need to be acutely aware of. And where is the law going in this area? Well, it'd be fair to say that it is growing at a pace. Here are some of the things going on at the moment. For those organisations that are the subject of subject to the Australian Privacy Act, and indeed for government entities essentially subject to the state privacy legislation, one of the key areas of focus going forward by the regulators, and indeed at the moment, is the regulation and the principle relating to the security of personal information. Helen touched on it earlier, APP 11. APP 11 has two components to it. One is that an organisation must implement reasonable security steps to prevent unauthorised access to personal information. That's one. And the other, which is APP 11.2, requires an organisation to implement reasonable steps to de-identify or to destroy personal information once it's no longer used for the purpose for which it was collected in the first instance. And this is an area, APP 11, that really has the focus of the Privacy Commissioner. She is on record as saying she's going to investigate organisations' security measures and she's going to make determinations about what they're doing or not doing. And the Privacy Commissioner did this recently. She issued a Commissioner-initiated investigation against Uber in relation to this APP 11. I just wanted to touch on this Uber decision, the determination of the Privacy Commissioner, because it's so relevant to us, I think, in practice. Very briefly, Uber was in the midst of moving its data from one system to another in a very general sense. And in that transition, Uber took a backup copy of all its data and put it on a backup server. The issue here was that once the transition occurred from system A to system B, the data remained on the backup server and wasn't removed. And it was the data in the backup server that was accessed by a cyber attacker. And it was that data that was exfiltrated. And long story short, in this instance, as a result of some investigations that occurred overseas, the Privacy Commissioner here in Australia decided to issue a commissioner-initiated investigation into the security practices of Uber. And the Privacy Commissioner, of course, can issue these investigations or conduct these investigations without the necessity of a complaint. No complaint was made by an individual. And indeed, the sort of information that was accessed by the cyber attacker included the names, email addresses, mobile phone numbers of drivers and riders of Uber, location information, although not trip information, and salted and hashed passwords. There was no trip history or credit card numbers, thankfully, that was accessed, but there was all this other personal information. So the Privacy Commissioner decided to investigate as to what happened here and to determine whether or not there was a breach of APP 11. This is in the context of a heightened focus on what organisations are doing to implement reasonable security measures to prevent unauthorised access and to destroy information once it's no longer needed. Now, cutting to the decision that's the determination that's really relevant to us, I think, today is that the Commissioner found that, in fact, Uber had not taken reasonable steps to destroy or de-identify the information that remained in the backup server after the transition to the new system occurred. And what I find really interesting about this one is that so many cyber attacks in recent times have occurred in relation to the backup systems of an organisation. So the primary systems are very well protected, but in some instances, the backup system has not been adequately protected. And this is exactly what happened in this instance. And the Privacy Commissioner held that there wasn't multi-factor authentication, there wasn't a rotation of access keys, no written policies about dealing with backup information, and there was no regular training in relation to the security measures that need to be implemented. So I think a really important lesson to learn from this determination, which was the first one that we've seen in relation to APP 11.2, which is the requirement to adopt reasonable steps to prevent, to destroy or de-identify information, is that one, you've got to have a very strong data and document retention policy in place. And when information should be removed or destroyed or de-identified, there should be a policy in place for that, particularly in relation to personal information. And the second important lesson from this determination, I think, is you treat backup arrangements in the same way as you treat the primary system. So speak to your technology department about ensuring that we've got very strong security measures in relation to our backups as well as our primary system. Folks, I want to mention a couple of other things. I already touched on the ransomware bill and where that's at. The Security of Infrastructure Bill is a really interesting piece of legislation that's currently before a Senate committee. And this is all about uplifting security and resilience requirements in critical infrastructure sectors. So at the moment, the Security of Infrastructure Act applies to entities in the electricity, gas, water and maritime port sectors. And essentially what's happening with this bill is that it is extending the remit of the Security of Critical Infrastructure Act to a number of other industries that I'm sure many of us are involved with or work in. And it is uplifting the requirements in relation to cyber security in particular in relation to all of these sectors. Let me just mention these sectors. I've put a few in the slide, but I think I might just mention all of them now so that you can make sure that either you've dealt with this or if you haven't, then you're aware of the fact that once it gets through, it will apply to your organisation. So these are the sectors that the new security requirements are going to apply to. Sectors in communications, financial services and markets, data storage and processing, the defence industry, higher education and research. Effectively, all our universities are going to be the subject of this legislation. Energy, food and grocery. Why food and grocery? Because if a cyber attacker gets into the supply chain in relation to the sale of food, supermarkets, then that could be a significant. That could result in a significant impact, as you can imagine, for the community. Healthcare and medical, space technology, transport, and water and sewerage. And these are all the industries that once this legislation gets through, and we expect it will, will be subject to a variety of increased obligations. What are they? There will be new positive security obligations, they're called, under this legislation, which is essentially going to require a risk management program that has to be agreed once the industry, and these are going to be the subject of rules between the industry and the government. Once they're agreed that apply to a particular industry, then the security obligations must be met by all participants in the relevant industry. There's going to be mandatory reporting of serious cyber incidents to the Australian Signals Directorate, in addition to other mandatory reporting obligations. So if you're in the financial services industry, you've already got reporting obligations under the Privacy Act, you've got reporting obligations under CPS 234, and you're going to have reporting obligations under the Security and Infrastructure Act once it applies to you. So there's a fair bit for General Counsel to be aware of in particular industries. And the sort of reporting, though, will be different here, because you'll be asked to report on the nature of the cyber attack, who attacked you so far as you're aware, what they're demanding in terms of amounts of money, the cyber wallet that you're paying money into, or you won't be paying money because it'll be all in cryptocurrency. That's how ransomware is paid nowadays. And a variety of other pieces of information that you'll need to report on. One interesting aspect of this particular bill at the moment, folks, is the fact that in certain instances, a member of the relevant industry may be required to allow the Australian Securities Directorate to actually take over and run your systems for the purposes of dealing with a cyber attack. Now, this will only be after the ASD directs you to undertake certain activities and you decide not to. They can actually force themselves, if you like, into your systems to enable the cyber attack to be dealt with, and particularly the security aspects of it to be dealt with. You're also going to be required to, if you're in the relevant industry, report the details of ownership and information relating to the assets of your organisation that have been attacked to the Department of Home Affairs. So the Security of Infrastructure Bill is something to be really mindful of when it comes to obligations of organisations in relation to cybersecurity in these particular sectors. I also want to mention, if I may, the Australian Government's call for views, as I've got up there, on strengthening Australia's cybersecurity regulations and incentives. This is a paper that was issued just a few weeks ago, and it's open for submissions at the moment. Submissions are due to close, in fact, later this week. And the Australian Government is considering a number of other initiatives. Bearing in mind here, we've got the Security of Infrastructure Act, we've got issues that ASIC and APRA are dealing with, we've got the increased focus of OAIC, but we've got this call for views from the Australian Government through the Department of Home Affairs about, well, what else should we be doing? And these are some of the things that we're thinking about in terms of the protection of assets and cyber security more generally, that we would like to talk to you about and receive your views on. Here are some of the things that they've raised in this call for views. They are considering, this is the Department of Home Affairs at the Commonwealth level, considering voluntary or mandatory governance standards for large businesses. They haven't defined what a large business is. What they're saying is we might want to introduce a voluntary standard, but we might want to introduce a mandatory governance standard. Essentially, a set of standards, if they're mandatory, that organisations will need to meet in terms of their data and their security. It will be mandated. If it's mandatory, it'll be mandated, and that you must meet, if this thing gets through, you must meet in order to comply with the legislation. Uplifting cybersecurity. They're also considering a cybersecurity code for personal information. This is going back to APP 11. What does this mean? At the moment, there is no, if you like, white list of security measures that the Privacy Commissioner will say are reasonable in terms of the reasonable steps you must take to prevent unauthorised access. She recommends quite a few things in her guidance on what amounts to be reasonable steps, but there's no white list. You must do this, you must do that. There's nothing mandated in that way. It very much depends on the nature of the information, the nature of the industry, and a variety of other factors that are relevant as to what steps you take. However, this paper is saying, well, perhaps we should be introducing a code for the actual protection of personal information, a code that needs to be adhered to by relevant participants. Again, potentially mandating a set of technical requirements that must be maintained by all organisations who hold personal information. The call for views also talks about increasing legal remedies for consumers in the event of a cyber attack. So it's interesting at the moment, individuals, if there is a privacy breach, can take a representative action under the Privacy Act, which is similar to a class action. But the Home Affairs Department is saying, well, look, perhaps we should think about more individual type rights of action for consumers, similar to, for example, rights under the ACL in relation to consumer guarantees in the event that a cyber attack occurs. That remains to be seen as to how that pans out. But just to put it on your radar that, you know, I suppose, in conformance generally with increased rights of individuals, we're looking to have increased rights of consumers in this area. When I say increased rights of individuals, the Privacy Commissioner in her submission in terms of the review of the Privacy Act was talking very much about enhancing individuals' rights of action. So inevitably we'll end up with a right of erasure, a right to be forgotten, as they have in Europe. So there's just generally a focus on increasing legal remedies for consumers in the event of privacy breaches or cyber attacks more broadly. Folks, there's so much to talk about, but that's just a thumbnail sketch of some of the things that are going on in the industry and some of the initiatives. Can I just quickly hand over to Michael to pick up the area of cyber insurance, which is so relevant. And next slide. Thanks, Michael.
Just need to work out the unmute. Thank you very much, Phil, and good morning, everybody. Cyber insurance is something that I wanted to talk about because what we see when clients come to us with a cybersecurity breach is a great deal of uncertainty about what is going to be covered and what is not going to be covered by their insurers in responding to the data breach or the ransomware attack. I thought it'd be useful for us to go through what is typically covered in a cyber insurance policy, as well as what is typically excluded in a cyber insurance policy, so that you can get a feel for the types of things that are going to be available to you from your insurer and have an understanding of where the areas are that your organisations may find themselves uninsured and needing to bear the costs of themselves. The first thing to say is that there is no standard template for cyber insurance policies that has become industry standard in the way of, say, a workers' compensation insurance policy or a motor vehicle policy. These policies can be highly bespoke or they can be off the shelf. Some of the off the shelf policies are excellent. Some of the off the shelf policies are much less excellent. One of the things that I do encourage every organisation to do, if they're not doing it already, is make sure they're having a very thoughtful discussion with their risk team, their insurance brokers, and their lawyers about the cyber insurance that they have, whether it is enough for the risks that they face, and what ought to be covered and what ought to not be covered for their particular circumstances. There was a question in the Q&A as to whether we are seeing increases in insurance premiums, and have we seen any major changes? The short answer is we have seen increases in insurance premiums and we have seen major changes. One of the major changes we're starting to see is that cyber insurance is coming out of lots of other policies that had it as an add-on or a paragraph in, for example, a business interruption policy or a professional indemnity policy. Insurers are requiring organisations to write cyber insurance policy, or to have cyber insurance policies written separately to their other suite of business insurance. So that's something that is both increasing the cost and increasing complexity for our clients. And that's something that companies need to bear in mind. Juliana, could I have the next slide, please? What is typically covered in a cyber insurance policy is, look, a range of things that you can expect to find. The first one, and the most understandable issue, is the incident response expenses. They are the costs that you are going to incur in responding to your cybersecurity breach and effectively managing the immediate issues that arise. So getting the hacker out of your system, understanding the scope of the vulnerability, and understanding how it is that your organisation is going to need to respond in terms of both incident management and in terms of notifications, whether to individuals under regimes such as the Privacy Act or under contractual obligations to other parties. Incident response expenses typically include cybersecurity consultancies, and within that, forensic investigation response. They also typically include your legal advice, and they will very frequently also include your communications advice and any other similar professional advice that you need to receive in order to allow your company to manage this incident. For good companies who have done their work, they will have a cyber insurance response plan with all of their organisations, their lawyers, their PR agencies, their preferred cybersecurity consultancies pre-identified, and it's often quite prudent to take these to your insurer and confirm that their costs will be covered. Many insurers will insist that you use firms from their panel, or will seek to limit your use of off-panel firms to specific circumstances. So having those expenses well understood in advance is a very good thing. Cyber insurance policies do cover the business interruption caused by the cyber insurance costs. Cyber insurance incident. Now that is effectively the difference between the revenue that you would have received and the revenue that came in as a result of the cybersecurity incident. This is one of those clauses that has come out of standard business interruption insurance policies and been specified specifically in cyber insurance policies. They can often be specified differently, so it is worth having a look at the specific terms of the business interruption coverage that you're getting in your policy, but it is usually there. The next one is the data and system recovery costs, which is what is required to get your company back up and running from an IT point of view. Now, that's a little bit different from the incident response expenses, but there can often be a bit of an overlap. This will be essentially the costs for you to restore your data and restore your systems, have them up and running, any interim costs that you've had to incur in terms of getting something up and running so that you can continue to have business conducted, or that your clients can continue to access their information. All of that will be covered under this head. Where this does run into issues with insurers is where companies want to build back better. And you need to be having a discussion with your insurer about what they will and won't cover in terms of data system and recovery costs, and what it is that your organisation thinks it wants to do as it rebuilds its system to ensure that future risks are well and truly mitigated. For example, a lot of companies do want to put endpoint protection on all of their systems after they've been breached. Now, that can be fairly expensive, and we are finding insurers pushing back on having stuff like that classified as system recovery costs. They're saying they're effectively future operational costs of the business. Cyber extortion damages and expenses is a really interesting one. We've spoken a lot about ransomware, and this is effectively insurance for the ransoms and for the costs of managing the ransoms. So quite frequently, organisations will engage risk companies to help them manage the negotiations with the ransomware operator and to facilitate the payments and to ensure that they are going to get their data back. So those costs are frequently covered, as are the actual ransoms. And we'll get on to, and Phil touched on a little bit, the ethics and legalities of paying ransoms. But as Phil said, the current rule is that they are legal, and the current insurance market does cover them. The next thing is your legal risk, which is the damages and costs of responding to legal and regulatory claims and investigations. And that's fairly self-explanatory, but it will cover OAIC investigations, including the representative action through the AIC. It will also cover direct litigation and responding to legal threats. Also, direct financial loss caused by cyber insurance can typically be covered. This is something that we see in some policies and don't see in other policies. It's worth looking at your policies or alternatively having a discussion with your insurer to write that back in if it isn't covered. Can I have the next slide, please, Juliana? It's interesting to talk about what is typically excluded in a cyber insurance policy. The first thing that's excluded, and this can come as a surprise to organisations, is intentional acts from companies and their employees that cause the data breach. So intentional internal hacking, intentional data leaking, those sorts of things are typically excluded unless you go and get specific coverage for those risks. One of the things that I think is really interesting is wrongfully collected PII is typically excluded from policies. Now, what that is personal information that your company might hold that it does not have any right to hold, either because it has not complied with its obligations under the APP, or somehow it has become the recipient of stolen or other wrongfully collected personal information. And there are risks for organisations right throughout their business in relation to this. One of the ones that I want to draw organisations' attention to is the dichotomy between the obligation to de-identify and clean up personal information that you hold when there's no longer a valid reason to hold it, and this clause. I've not seen it tested yet, but I would not be surprised if that becomes a real issue between clients and their insurers. Obviously, if you have wrongfully collected PII, you have all of the legal obligations that go along with holding that PII should there be a breach. You still have to notify the AIC. You still are going to have to notify the individuals if it's a notifiable data breach. You may still find yourself the subject of litigation, but what you won't be is insured for that. So that's something that I want to put on everybody's plate because I think it's under-recognised. Warranties, guarantees, and liquidated damages clauses in your contracts with third parties are typically excluded. This is something that we're actually seeing a fair bit of action in because you are getting this issue arising between organisations that engage for services requiring warranties, guarantees, and liquidated damages clauses in relation to cybersecurity, and the fact that they are typically excluded from cyber insurance policies. So this is something where, with a negotiation through your broker or with your insurer, you can get this written back in, or you can get specific instances insured. It is worth reviewing your contractual position in relation to warranties, guarantees, and liquidated damages clauses, and making sure your insurance is going to cover those in the event of a data breach, noting that it seems to us that the typical position is that policies are excluding these liabilities. Finally, payment card losses attributed to non-compliance with the payment card industry data security standard tend to be excluded. I've not had an instance where anybody's tried to go back to the insurer and say, no, we should be covered for that. I think the understanding on both sides of the industry is organisations that are holding payment card data must be complying with that standard. As Phil Catania mentioned, there are a range of other industry standards likely to be introduced through things such as the Security of Critical Infrastructure Act, and we may well see other security data standards becoming the subject of exclusions in certain industries, particularly where there are sort of basic and well understood standards. If I could have the next slide, please, Giuliano. I'm also going to talk about a question which has come up a couple of times in the Q&A about the legalities and ethics of paying the ransom. I'm actually going to start with the bottom half of this slide. The government's position is that you should never pay a ransom. The Australian Cybersecurity Centre gives strong advice that paying ransoms should not be done for a number of reasons. First of all, you do not have any guarantee that you're going to get your data and information back, or that if they have exfiltrated your data as well, that they will not keep a copy and release it somewhere in the future. That's a very practical issue. The other reason why the ACSC and the government say you should never pay ransoms is because your organisation and organisations in Australia more broadly then become known for paying ransoms and will become a target for ransomware in the future. That's the government's official position. As we've seen, and as Phil mentioned in relation to the ransomware payments bill that is making its way through, the government acknowledges the practicalities that businesses find themselves in and acknowledges that organisations are in fact paying ransoms, and unfortunately that is part of responding to a cybersecurity breach in the current age. So it's not illegal. There are some issues which I will now jump to that need to be taken into account when a board is making a decision as to whether to pay a ransom. The first is anti-money laundering and CTF obligations. Now, these apply to deposit-taking institutions, and they will have an obligation to report ransom payments to AUSTRAC where they have a suspicion that the payment may support money laundering, terrorism financing, or may otherwise constitute an offence. So even as an organisation, you could see a banking institution making a report to AUSTRAC for a large purchase of Bitcoin, Ether, or some other coin. The next thing I want to say is the Commonwealth Criminal Code has two sections that are relevant. Division 400 makes it a crime to make a ransom payment where the ransom payment may be used by the recipient to commit an offence, and Section 102.7 makes it a crime where the recipient of the ransomware payment is or may be a terrorist organisation. It is also a crime under the Charter of the United Nations Act 1945, where the recipient of ransomware payments is a subject of UN sanctions. There are a number of things to say about those crimes. Typically, organisations are paying under duress, and duress is a defence under Section 10.2 of the Criminal Code. It is also a defence under the Charter of the United Nations Act if the organisation takes reasonable precautions to avoid contravening UN sanctions. All of this is great as a matter of black letter law. As a matter of practicality, the reality is you generally do not have any information whatsoever about the organisation or person who is asking for the ransomware payment. We know, largely through communications that come from the intelligence community and the cybersecurity community, that there are a range of actors in the ransomware space. Some of them are opportunistic criminals who are doing this for a living. Some of them are organised crime, cartels, mafias, etc. Some of them are government organisations or people acting at the direction of government organisations, and in particular, governments who are on the sanctions list and need to find ways to access capital. For an organisation that is the subject of a ransomware attack, there are some investigations that you can do, and you can engage security consultancies to ascertain whether there is anything in your in the hack that leads them to believe that there is information that might trigger one of these crimes, but nearly uniformly there is not information. And against that background, it is very hard to see a criminal prosecution or an issue of illegality arising from the point of view of paying a ransomware, particularly in circumstances where, as I said at the start, there is no specific legal provision that prohibits the paying of a ransomware attack. I'm going to move on to what the insurer might say about this issue. As I've said, the insurers provide for the payment of ransomware and for the management of the ransomware payment in most policies. It is something that is done. The insurers find themselves in a fairly tough position here. On the one hand, even though, as we saw in some of the slides before, the costs of ransomware are going up by about 40 or 50% a year, those costs are still significantly less than the otherwise insured business interruption costs that would be caused to a company if they had to rebuild their data and rebuild their business. So currently the economics tend to favour the payment of ransomware ransoms, but on the other hand, as the government has pointed out, insurers also have a very strong interest in not becoming a bank for criminals. They do not wish to become effectively the overall target for all the ransomware payments. Ultimately, though, what we have seen is insurers will accommodate ransomware payments. Then you have the ethical considerations, and these are very difficult. The first thing that I should say is when a company is exercising its decision-making processes about whether or not to pay a ransom, ordinarily they're doing it at the executive management and board level. And at that level, they have to make a decision that is in the best interests of their company. And those best interests will depend upon a number of things. As Phil Catania pointed out, is the attack one that is stopping them doing business, or is the attack one that has locked up some data they don't care very much about? If it is a situation, as it frequently is, where there is a real loss or risk of loss to the business, I think the overall obligation is actually the business judgment rule that sits in section 180 sub 2 of the Corporations Act. That is, directors' decisions, if they're made with care and skill and having regard to all of the available information to pay a ransom, I think are highly justifiable and probably required under the Corporations Act as a board and as an executive acting in the company's best interests. The other, I think, ethical considerations tie in with what the government has said about the reasons not to pay ransoms. I think, however, the market is very clear that it is not a matter of blaming a company for paying a ransom. There have been a number of ethical discussions about this point. There's actually a very good paper from the Queensland Law Society on this point that actually looks at the obligations of law firms when they're paying ransoms. It makes the point, and I think the point is right, that a person who pays a ransom is no more responsible for the crime than a person who hands over their wallet with a knife at their throat. It is not a matter of blaming the victim for the circumstance that they find themselves in for taking the necessary steps to prevent further danger and get themselves out of that pickle. So I think the ethical considerations still at this stage will tend towards payment of the ransom, unless there are some other overriding obligations such that you will breach one of the laws that we've mentioned, or alternatively, actually the data that has been locked up has no value, is not PII, and really all you are doing there is effectively making a payment for a loss that may not be a realistic loss for the business. So that's what I wanted to say about the legal and ethical issues associated with paying ransoms. I'm now going to hand back to Phil, our wise man on the hill, to give his 10 commandments in relation to cybersecurity.
Thanks, Michael. Perhaps just before these so-called 10 commandments, they're really just some principles we wanted to leave you with as legal counsel. Just a few things about what Michael said, and to emphasise a couple of things. By way of example, I've in the last couple of years acted on 3 ransomware attacks for the organisation that was hit with the cyber attack and where the ransom was demanded. In all 3 instances, the company paid the ransom, and in all 3 instances, the data was released or the system was opened up. So the attacker actually undertook what it said it would do if the ransom payment was made. Now, that's not to say that will always happen, of course, but it did happen in those 3 instances. And interestingly, I suppose not only was the payment made in cryptocurrency, so it was, couldn't be tracked. The amount that was set was high, but not too high that the ransom attackers would know it wouldn't be paid if it was too high. So they're setting it, this is a business for them, and they're setting it with a view to having the payment made. If it's set too high, it won't be paid, and they'll realise that they won't receive what they wanted to receive. The second thing to say about the insurance position, Michael's absolutely right. Insurance companies have been paying out the ransom amount, but in fact, I think we're going to be finding that that's changing. And so when you come to your renewal of your cyber insurance, or your PI insurance, because it could be covered under your PI, you're going to be finding, I think, that insurance companies are now culling the payment of ransom payments out of the cyber policy. So be really mindful of that. And it's starting to happen. Can I just mention, there are a couple of questions also raised. I might just quickly address them now very quickly, if I may, Haveen, because they're relevant. A question was raised about whether or not about the current government proposal to make directors personally liable for cyber breaches. I don't think that's my reading of it. That this comes out of the call for views that I mentioned earlier about strengthening Australia's cyber laws. And the federal government's out there saying, look, we want to strengthen cyber laws. I don't think that the government's actually proposing that directors will be personally liable for cyber breaches. To pick up Michael's point, having individuals liable for that by the mere fact that a cyber attack has occurred I don't think will mean that the directors will be automatically liable. I think the issue is whether or not the directors ensured that the relevant standard was adhered to, or the relevant procedures and processes were put in place. And that's what the cyber codes are about in the call for papers, seeking views about whether these codes, in terms of the security standards, should be voluntary or mandatory. I'm not seeing though that just because a cyber attack has occurred, the director will be personally liable. I think it's broader than that. There's another interesting question that was raised about the Marriott Star Awards incident and changes to M&A deals in terms of warranties and reps. What happened in this instance, and I need to be a bit careful because I acted for Marriott in relation to this matter here, not in relation to the sale, but very quickly Marriott purchased the Starwood hotel chain in 2014. In 2016, sorry, in 2014, 2 years before the acquisition, there was a cyber attack on the Starwood. That's the target's computer systems, but the cyber attack in which a whole lot of people's personal information, customers of the Starwood hotel chain, was exfiltrated again from the backup system. You see, similar to Uber, a whole lot of that personal information was exfiltrated, and but it wasn't detected until 2 years after the acquisition took place. And by that stage, the Marriott had taken over Starwood, and this was a cyber attack that occurred on the Starwood system 2 years before the acquisition. This all occurred in the United States. And the question was, but there was a whole lot of Australian customers' personal information was taken, which is why the Australian Privacy Commissioner at the time investigated it as well. And the issue here is, well, what sort of reps and warranties should be included in share purchase agreements? And I think what I would say about this is what's certainly happening is that there is a much greater level of due diligence that is occurring in relation to cyber incidents that may have occurred on a target, and a much greater focus on the information security management system of the target, as opposed to any major change in reps and warranties, because you can imagine that the seller will have issues about giving certain reps and warranties in circumstances where they're not aware of a cyber attack. But the vendor will want certain commitments in relation to what may occur if there was a cyber attack. So there's that balance that's being worked out at the moment. But I will say that there's a much greater level of due diligence in relation to cyber attacks and in relation to this information security management system. So it's a nice segue into these 10 commandments. I'll be quick on these. If you haven't heard the term, you will. And if you did a Google search on the letters ISMS, the first thing that'll come up is Information Security Management System. This is a system that defines and manages the controls that an organisation needs to implement to ensure that their security is up to date. And yes, your organisation will have one. I would expect your Chief Security Officer will be aware of it. The one key thing to remember about this is to ensure, I think, that this is tested and updated regularly. That's the key on this. Part of the information security management system will be a governance framework. The second commandment, it'll be your policies about how to manage incidents. It'll be your policies about how to destroy personal information, touching on that before. It'll be the roles and responsibilities of people within the organisation in the event of an incident like a ransomware attack. It'll implement a cross-functional committee. There should be a cross-functional committee involving legal, procurement, technical, and so on that meets to talk about and deal with cyber issues. So a very strong governance framework will be something that needs to be implemented if it already hasn't been. We've touched on the fact that cyber attacks and security is a board responsibility. APRA says it in CPS 234, ASIC says it. ASIC has issued first set of proceedings against RI Investments. It's touched on in one of the questions for directors failing to implement adequate cyber security. The decision on that hasn't come out yet. There's been another decision that's not related to that in relation to that particular company, but ASIC is very much taking an increased observation and take an increased role in relation to responsibility of boards, ensuring that their cyber practices are up to date. We've touched on cyber insurance. Please check and update your cyber policy, your insurance policy. That's just an absolute given. On ransomware, we think it would be very useful to develop a position on what your organisation should do in terms of a policy and a procedure in the event it was hit with a ransom attack, and have a dry run of it. assess and address your reporting requirements and the roles and responsibilities of organisations. Now, this is being done more and more, having a dry run of a ransom attack and what to do if you have one, and that involves external lawyers, PR people, you know, your insurance, and so on. Can I just mention this thing very quickly about DSARs, as they're called? This is number 6, data subject access requests. One of the increasing areas of practice in Europe, where they have the General Data Protection Regulation, GDPR, is the fact that so many more individuals are making requests to access personal information held by them. And in that context, individuals are asking about the security that you, organisation, have implemented to protect my personal information. I think we need to be prepared for that happening more and more in Australia, and I think we need to have a position about how to handle that and the sort of information that we provide to consumers, individuals, when they make the same sort of requests here in Australia. Ongoing education of our staff is a requirement. It's APRA, it's ASIC saying it again, that we expect education to occur. That ought to be documented to demonstrate our good governance when it comes to the regulators who might want to have a look at what we're doing. Contracts with third parties about cybersecurity. You know, we suggest developing standard positions and your standard clauses that you need to include in relevant contracts with relevant third parties. Notification of breaches, folks. You've got to be aware of your obligations. They're growing, as I said before. There's more legislation about notification of data breaches, not only personal information breaches, but more broadly. So be aware of your responsibilities, and indeed, a notification of data breaches may not just apply to you in the context of a data breach that you've suffered, but maybe may also apply to a third party who holds your personal information. That's under the Privacy Act. So there's different obligations that may apply to different entities. And the final thing I'd say in terms of the 10 commandments, as it were, is the issue of privilege. It's really incumbent upon in-house counsel, I think, to ensure that in-house counsel takes a critical role in the conveyance of information about a cyber attack or a data incident, right? So we want to maintain privilege. You'll be aware of your obligations on that. That is critical for in-house counsel to be managing. There, at a high level, are the 10 commandments from on high. I might just stop there and hand back over to Harveen and thank everyone for your involvement today.
Yes, the Legal 500 would like to thank everyone who turned up. The session was certainly insightful. A special thank you to Helen, Michael and Philip for taking the time out of your busy schedules to share, you know, your insights. Definitely, it's been an insightful session. We could definitely see that from the types of questions that actually rolled in. I know that many of you will probably want to refer back to some of the topics covered. So we're happy to let you know that we have the session will go up on our on-demand platform in a couple of days. So stay tuned for that. I hope everyone enjoys the rest of their day and thank you.